right, and reset. All right, the next case is that of Seth Tendre.
Yes, sir.
All right, sir. Let's see. Well, we have burglary of a structure, and your bond is $3,500. Do you want me to appoint a lawyer for you, sir?
Yes, Your Honor.
All right. Office of the Public Defender is appointed, and this says Division KFW
17.
17. All right. And that's all, sir.
All right, thanks. So just write to the public defender? Just call for it. Okay, thanks.
All right. Next case is that of Alexander Glover. Is that you, sir?
Yes, Your Honor. Yes, Your Honor.
All right, sir. You've got a charge here of attempted burglary of a conveyance. Your bond is $1,000. You have applied for the Office of the Public Defender. However, you do not qualify, so that appointment cannot be made at this time. You're in Division 22, and as I say, the bond is $1,000.
Okay. All right, Your Honor.
All right, Nikita Jackson.
She's mental health, Your Honor.
All right, reset. Thomas O'Brien. Is that you, sir? Yes?
1 second, Your Honor. Let's try now.
All right, your name, sir?
to with you.
Your name?
To,
Are you Thomas O'Brien?
yes,
All right. Sir, you've got a charge here, aggravated assault with a deadly weapon. Your bond is $2,500. Do you want me to appoint a lawyer for you, sir?
yes,
All right. Office of the Public Defender is hereby appointed, Division 17. All right, Robert, excuse me, Robert Ars or Arcee?
RC.
All right, sir. You are out on a bond or PTR. That is stayed. ROR, yeah, that's stayed. You have a new case here involving disorderly conduct. Bond is $250. And do you want me to appoint a lawyer for you, sir?
Yes.
Division A, appointment made.
Your Honor, if I may ask if the state has an offer today for the city ordinance disorderly conduct?
Yes, Your Honor, we would offer adjudication of guilt, 3 days, credit time served.
Your Honor, my client accepts a plea no contest, adjudication guilty, 3 days, Orange County Jail.
All right. Two. Now, let's see, we got a trespass case, that was ROR, that is stayed, and then on the new case, disorderly conduct, the plea is accepted. There would be an adjudication, 2 days, time served, and court costs $273 payable within 1 year.
Thank you, Judge.
Yes, sir. All right,
Zeki. Frank.
all right, sir, thank you.
Yep.
Sir, you've got a case here involving a charge of trespass after warning. Your
Yeah.
bond is $500. You didn't
$500.
fill out the application for criminal indigent status. Is there an offer from the state?
Yes, Your Honor. Adjudication of guilt, 3 days, credit time served, and cost and no return to the scene.
Yeah, we already signed it. I can just get back to the court where I live at.
You don't have to take it.
Huh? Oh, we
You
don't?
want to accept that?
How long before I have to go to trial?
I can't guarantee you. 3 weeks before you.
Yeah, I might as well spend 3 days.
Your Honor, I'm not sure if I was appointed, but the gentleman to my, I don't believe I was appointed, but the gentleman to my right would like to accept the offer, he said.
All right, so noted and accepted by the court. So there would be an adjudication, 2 days credit for 2 days, time served, $273 in court costs payable within 1 year, no return to 1400 East Silver Star Road in Orange County. All right, the next.
Morning, Judge. Again, this is Michael Gibson on behalf of Derek Thomas, 48 2018 CF 17509, and he's standing to my right. And we're asking if the court would consider, at this initial appearance, setting him a bond in this matter.
All right, now, let's see, there's a bond already on which he's released. I can't tell whether it's 7,000 or 7,600. That would be stayed. Then there's another bond in the amount of 7,000 and another bond in the amount of $21,500. And then this violation of probation case and no bond at this time. So, oh, and there's an out-of-county warrant also, Hillsborough County. So he'd be transported to Hillsborough County as to that case. And let me see.
Your Honor, it's my understanding that he's going to be seen in the division court later, is that correct?
No, they just said to keep that, I had to stay in this court, actually.
Okay.
Yeah.
Then the state would ask that as to the violation of probation, that the no bond be stayed.
All right, that's in the paperwork here that was filed originally at Division 22 on this case, and then on the Hillsborough County case, bond is $2,000. Let's see. And on the VOP here, it is Division 22.
No bond in 2004 in Hillsborough County.
I'm sorry?
Is there no bond on the VOP in 2004, Hillsborough County?
Yeah, I believe the Hillsborough, there's a $2,000 bond?
Right.
Yes, but we're just asking if the court would consider setting a bond on the VOP this morning. Judge, if I can tender some testimony from Mr. Thomas, but he's got bonds on everything else, and we're just asking if the court would consider setting a bond this morning in this violation of probation case.
All right, and state's response?
Our response was to that he be held on no bond.
All right, let me see the file again. All right, now into the, as far as the Orange County case is concerned, this Orange County case for the VOP, the bond would remain at no bond without prejudice to address that later.
Okay, thank you, Your Honor.
Thank you. All right, the next file I have is that of Keon Green.
He's mental health, Your Honor.
All right, reset. Let's see, now, I believe Judge Kirkland, yes, had that. Now, when they, two refuses, do they appoint a public defender? All right, now, because of the situation here on the defendant's refusal, the court is going to appoint the office of the public defender at this time. All right, Felix Auguste?
Yes, sir.
All right, sir, you've got 4 counts of failure to appear. It would seem, let's see, 6, 7. Yes, and you're in a no bond status. Now, sir, do you already have a lawyer appointed for you?
Yes, yes, a PD.
All right, public defender has already been appointed, and that's Division 22. All right, and the next file is that of Ichano Coleman. Is that you, sir?
Yes, sir.
All right, sir, you've got a situation here where you are charged with violation of condition of pretrial release. You're in a no bond status.
You had a PD previously appointed.
All right, and the public defender was previously appointed, that's Division 20.
Government communication.
All right, the next file I have is that of Susan Dalby.
Yes, sir.
All right, ma'am, you've got a set of charges here. Failure to appear on the case, there's 3 counts as to that. And at this moment, you're in a no bond status.
PD previously appointed.
All right, public defender previously appointed, Division 12. All right, the next file is that of Judiath Diaz Lopez.
Yes, sir.
All right, sir. You're out on several bonds, it would appear, battery on a security officer, petty theft, resist merchandise recovery. Your bonds are stayed in regard to that, $2,500, $150, and $100. Now, you've got a new set of charges: possession of controlled substance with intent to sell, bond $7,500; possession of heroin, bond $150; possession of fentanyl, bond $150; and possession of cocaine, bond $150. Now, you have applied for a public defender to be appointed. However, you do not qualify at this time, so that request would be denied without prejudice. And on the new case, that's Division 19. And then you also have a driving while license or no valid driver's license, bond $500, Division A. So that's all for this appearance, sir. All right, next file is that of Ralph Duckton.
He refused to attend, Your Honor.
All right, reset. All right, and the next case is that of Rolando Espinoza.
Yes, sir.
Sir, you've got a set of charges here: grand theft, third degree of motor vehicle, bond $1,000; resisting an officer without violence, bond $100, Division 22. Do you want me to appoint a lawyer for you, sir?
Public defender.
Yes.
All right, Officer of the Public Defender is appointed. You qualify, and this case is assigned to Division 22. All right, next file is that of Jeffrey Hartsoe.
Yes, sir.
All right, sir. You've got a set of charges here. Robbery. The bond was mistakenly set at $2,000. It should be $10,000. So that is ordered at this time. Resisting an officer without violence, bond $500. Petty theft, bond $500. Resisting a merchant, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. Office of the Public Defender is appointed Division 11. All right, next file is that of Jason Lennon.
Hospital, Your Honor.
All right, reset. All right, next case is that of Bruce Madison. Is that you, sir?
Yes, sir.
All right, sir, let's see. All right, sir, you have a set of charges here. Trafficking in heroin, more than 28 grams, $75,000. Unlawful use of a two-way communication device, bond $5,000. Do you want me to appoint a, well, let's see, I don't know if you,
All the way to the end.
hmm?
All the way to the end.
All right, do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defender is appointed, and we have Division 10.
Your Honor, can we speak about bond? If we can reduce the bond?
All right, what's the defense request?
The defense request is we reduce it to the amount of $25,000. I base it upon that my client has, and it's counterintuitive, but my client has 12 felonies, 2 misdemeanors, however, 0 failures to appear. Bond is meant to ensure that our client, or excuse me, my client appears to court and doesn't miss any court dates. Yes, you look at the criminal history, but at the same time, we need to take in consideration that he does show up to court. He does show up when he's supposed to, Your Honor. Thank you.
All right, and state's response.
If we could reduce it to 50 instead, Your Honor.
I'm sorry, I couldn't hear you because of the machine here.
If we could reduce it to 50 instead, Your Honor.
She's 50,000, she's requesting 50,000.
Okay. All right, we'll go with 50,000, count 1, 5,000, count 2.
That's our number. That's your case.
All right, the next file is that of Sedeno Martino.
Hospital, Your Honor.
Reset. And next file is that of Jaslyn O'Neill.
Your Honor, this is a PBL, and we're asking that we move this to the afternoon session.
All right. And the Office of the Public Defender will be appointed. All right, John Porter.
Yes, sir.
All right, sir, you have a new case involving possession of cocaine. Bond $1,000 as Division 11, and the bond on which you are released presently, possession of cocaine and possession with intent to sell or deliver, your bond is $2,650. You posted that. That would be stayed. The new case has a bond of $1,000, appointment of the public defender, and it says Division DKB.
11. 11, Division 11.
Okay, Division 11. What's with the DKB?
Denise Gilbina.
Oh, okay. All right, the next file I have is that of Edo Reyes. All right, now, ma'am, you've signed the application for criminal indigent status. You qualify for that, Division 14. Now, as to the charges, trafficking in oxycodone, bond $100,000. Trafficking in oxycodone again, bond $100,000. Trafficking in oxycodone, bond $10,000. Trafficking in hydrocodone, a bond $10,000. Trafficking in hydrocodone again, bond $10,000. Trafficking in hydrocodone again, bond $10,000. Trafficking in oxycodone, count 7, bond $10,000. Count 8, the same $10,000 bond, trafficking in codone. Then count 9 is trafficking in oxycodone, bond $10,000. And then, let's see, looks like 11 charges of sale or possession of altered prescription. That was blank. Your bonds are $1,000, count 10, and $150, counts 11 through 20, respectively. Now, do you want me to appoint a lawyer for you?
Yes.
All right, public defender is appointed, Division 14.
Your Honor, if I may speak about in the premise of bond, Your Honor.
All right,
Right now, through my math, and it could be off, I have $272,000 and $150. So at this point, as her counsel, I looked at this paramount to no bond. I looked at her criminal history, and I have a criminal history of 0 felonies, 0 misdemeanors, i.e. 0 failures to appear since she has no criminal histories. I have on here, there's no arrests in the state of Florida either. So at this point in time, I'd ask that we reduce it. I understand the charges are serious. I do understand that. But I believe a more reasonable bond would be at $75,000. Again, for the purposes of her to appear to court, and she's never been arrested, I believe that $75,000 bond is more reasonable, Your Honor. Thank you.
all right, and state?
State could agree to a reduction to $100,000.
Well, we've got 2 $100,000 bonds. Now, which,
I was referring to 100,000 total versus the 270 plus that the public defender referred to.
all right, So ordered.
You're gonna have to give it to me in per, count.
Oh, per count?
Is what you gonna break it down, somebody gonna break it down?
If we could take the approach right now is, Your Honor is inclined to, we could take the first count, which is trafficking oxycodone greater than 25 grams, less than 100 grams is 75,000. And then the remaining counts could be subsidiary at that point in time if the state's fine. And if they're subsidiary, then we can do 150 for each count.
All right. State agree with,
Let's go with 100 for the first count and then the subsidiary amount for the subsequent.
We're fine with that, Your Honor. Thank you.
all right. Then count two would be 25,000. And the others would remain as previously stated. Yeah. On count two. 100,000 count one, count two, 25.
Okay. Okay, put on the record so they can hear what you said.
All right. Now, as I understand it, the bond has been agreed, count one, at 100,000, count two, 25,000. Is that the understanding?
Yes, Your Honor, and then we agreed to, was it 125 that you asked for each of the subsequent counts?
What I had taken the approach, Your Honor, was 75,000 the first count, and all remaining counts, subsidiary of $150. The state subsequently said 100,000 for the first charge, and then the remaining would be 150 for subsidiaries. So the total would be 100,000, and my math was going to be completely off here, but some change. It's like 100,000 and $2,000. So it'd be something to that effect. And again, I think if we're at this point in time at 100,000 plus some change. We're already at that point where it's going to be difficult for my client
Yes.
to get that amount of
All right.
money.
Then that would be so ordered as agreed. All right, the next file is that of Donald Redenpaugh.
Donald Rittenpaugh.
All right, sir. Sir, you have a set of charges here. Possession of ammunition by a convicted felon, bond $5,000. Possession of firearm by a convicted felon, bond $150. Possession of drug paraphernalia, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defenders appointed, that's Division 16. All right, the next file is that of Bernard Robinson. Is that you, sir?
Yes, sir.
All right, sir, you've got a capias here for failure to appear, 2 counts, it looks like. At this moment, you're in a no bond status. Was a lawyer previously appointed?
No.
Well, I have no application for criminal indigent status. What do the other judges do?
Ask him if he's gonna get his own attorney.
Your Honor, he just stated to me he's in the process of getting a private attorney for that case.
All right, and that's Division 20. All right, next file is that of Adalberto Rodriguez Jr.
Alberto Rodriguez Jr., sir.
All right, sir. You have a set of charges: possession of heroin, bond $1,000; possession of drug paraphernalia, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes, I need an attorney.
All right. Public defenders appointed, Division 10. All right, next file is that of Gabriel Roldan.
Yes, sir.
All right, sir, a couple of cases here. Grand theft, third degree of a motor vehicle, bond $1,000. And then the next case is that of driving while license revoked as habitual offender, bond $2,500. Now, sir, do you want me to appoint a lawyer for you on these cases?
Yes, sir.
Public defender is appointed. That's Division 16. All right, Mark Schaller.
Yes, sir.
Sir, you've got a set of charges here: attempted burglary of a dwelling with assault or battery, no bond, and resisting an officer without violence, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender is appointed, Division 22.
I apologize, Your Honor. I didn't hear a bond amount. I apologize.
Okay, no bond, count 1, count 2, $500.
And, Your Honor, it's not a PBL, the first charge, so I'd ask that a reasonable amount be set for that bond. The attempted burglary of dwelling, assault, and battery.
All right?
So I just asked a reasonable amount since $15,000, Your Honor.
And state?
$25, Your Honor.
All right, a bond would be set in the amount of $25,000 instead of no bond. And let's see. Sir, do you live at 4119 Minnow Court?
Yes, sir.
Well, I'm going to say no victim contact, and that is Division 22.
Did you take any action on the?
Oh, that stayed. The bond on which it's released is stayed. All right, the next case is that of James Sims.
Yes, sir.
All
Your
right,
Hon-
sir.
Your Honor, this is a PBL, and we would ask for it to be moved to the afternoon session.
Your Honor, if I may, for Public
Yeah.
Defender's Office, at this point in time, if the state's asking to be moved based upon his PBL, if this afternoon, if the state will need to explain to us how it's a PBL, because the charge itself, It's only being PBL depending on what statute that the state is saying it's going to be falling under, i.e. his criminal history. There's 3 separate statutes she'll need to inform the court and the public defender's office. But we're fine with resetting to this afternoon, Your Honor.
All right, so ordered, we'll reset. All right, next case is that of Daquan Tate. Is that you, sir?
Yes, sir.
All right, sir, you've got a failure to appear capious on 2 counts or 2 charges. Do you already have a lawyer, sir?
Yes.
Previously appointed to PD, Division 22. All right, Audrey Walker?
Yes, sir.
Ma'am, you've got a couple of cases here, possession of cocaine, bond $1,500, introduction of contraband into a county facility, bond $150, and then another charge, possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you?
Please.
All right, public defender appointed. Let's see, Division 20, it would appear.
The other case hasn't been entered. We're having trouble with the computer, so they don't have a case number on that case yet.
Okay. All right, the next file is that of Ronald Yant.
Yes, sir.
Sir, you have a set of charges. First, you're out on bond on 2 cases on which the bonds are stayed. $15,850 on one case and $5,000 on another. Now you have these new charges: possession of methamphetamine with intent to sell or deliver, possession of cocaine with the same intent, and possession of cocaine simply. Now, so your bonds are $15,000, bond $150, bond $150. So those bonds total what, $15,300. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed. Now, I don't have a division
It's
number,
going to be 17.
Division 17.
Your Honor, if I may, on the bond amount, on the first charge is $15,000. I'm asking if we can reduce that to $5,000. I base that in part, Your Honor. My client does have 9 felonies and 4 misdemeanors. If we look at his failures to appear, he has 2, but the last one was in 2008. Again, the purposes of bond is so that my client will appear to court. So I believe that at this point in time, if we reduce his bond to $5,000, Your Honor.
All right, and state?
State will agree to a reduction to 10.
You said 10?
Yes, Your Honor.
All right, I'll go with the state, $10,000 on count 1 and $150 on 2 and 3. All right, Justin Berg.
Yes, sir.
All right, sir, you've got a charge here of trespass in an occupied structure, refusal to leave, bond $1,000. The Office of the Public Defender is appointed, you qualify. Now, on this case, is there any offer from the state?
Yes, Your Honor. Adjudication of guilt, 3 days, credit time served, court cost, no return to scene.
Your Honor, may I just speak to the state for one moment, Your Honor?
Yes.
Thank you.
Your Honor, on this one, we have agreed to withhold.
Say again, please.
Your Honor, on this particular case, he has no prior trespass, and we have agreed to withhold adjudication.
All right.
I apologize. Was it credit time served?
3 days with credit time served.
All right, I have 2 days served, so that'd be one more day.
The jail will let him out today.
Say
The
again?
jail would release him today with 3 for credit for 2. They give him that extra day.
All right.
Your Honor? My
Yes.
client appreciates the state's offer, but at this point in time, he's not going to accept it.
All right. Public defender is appointed.
And if I may, Your Honor, for the purposes of bond, my client has 0 criminal history, and he's 33 years old, so I ask at this point in time if we can do ROR or PTR. I'm not sure if he, I'm not sure.
Qualify for PTO.
He does?
He does not.
Oh,
Correct. So if we could do ROR, Your Honor, based upon his criminal history, the lack of it, I should say, Your Honor.
all right, and state's response?
Let's at least do a $100 bond.
We'll go with the $100. All right, and the next case is that of Linda Dyke. All right, now, ma'am, you've got a charge on trespass on property after warning. Bond is $500. Is there an offer from the state on this case? Public
Adju-
defender appointed.
Adjudication of guilt, 3 days, credit time served, court costs, no return to scene.
Your Honor, my client accepts the offer, and please no contest, adjudication guilty, 3 days Orange County Jail, and no return.
All right, there would be then ma'am, you want to accept that offer?
Yes.
All right, there would be an adjudication, 3 days with credit for, well, 3. And court costs, $273 payable within 1 year, and no return to this location at 3201 West Colonial Drive in Orange County. All right, the next case is that of David Grisby.
Yes, sir.
Sir, you have a charge of trespass on property after warning, bond $500. I have no request for a lawyer to be appointed. Is there an offer from the state?
Yes, Your Honor. Adjudication of guilt, 3 days with credit time served, court costs, no return to the scene.
Your Honor, can I just be appointed to assist him right now, Your Honor?
All right, so ordered.
Thank you. What you're doing is adjudication of guilt. I'm going to get 3 days away from the jail, okay? No return, okay? Good? Okay. It's not gonna happen because the criminals, that's what you're saying, okay?
All right, sir, is that what you wish to do, accept the state's offer?
Yes, sir. I would just,
You signed it.
All right. There would be an adjudication, 3 days, credit for time served, court costs $273 payable within 1 year, and no return to 902 Lee Road, number 26. All right, the next case I have is that of Lachelle Hamilton. Is that you?
Yes.
All right, ma'am, you have a charge, retail petty theft, bond is $250. You want me to appoint a lawyer for you?
Yes.
Public defender is appointed, Division CRA, it says. Now, on this case, is there any offer from the state?
Yes, Your Honor. Adjudication of guilt, 5 days with credit time served, cost, and no return to that Walmart.
Your Honor, if I may, my client has zero history, so as a counsel, pretrial diversion is more likely than not probably going to happen. So I asked at this point in time if we can have bond from 250 to ROR so that we can go forward and get the best outcome for our client. She can't afford the $250. That's why she's initial appearance. Again, 0 felonies, 0 misdemeanors, 0 failures to appear. She's 46 years old and she has no criminal history. So if we can just do ROR at this time, Your Honor.
All right.
Yeah, and the potential, my point is as her counsel is more likely than not, we'll be able to remedy this situation in a better manner than her pleading guilty today in court with her criminal history.
All right.
Then the state would ask the bond be reduced to $100.
All right. So ordered, $100, and counsel's appointed. All right, next case is that of William Leroy. Is that you, sir?
Yes, sir.
All right. Sir, you have a charge of trespass on property after warning. Your bond is $500. On this case, is there, and the Office of the Public Defender is appointed, on this case, any offer from the state?
Yes, Your Honor. Adjudication of guilt, 3 days, credit time served, no return to the scene.
Okay.
Your Honor, my client accepts it. Adjudication guilty, 3 days Orange County Jail, and no return.
All right, there's a factual basis here, so the plea would be accepted, adjudication would be imposed, and did the state say 2 or 3 days?
3 days, Your Honor, with credit time served.
All right, so ordered, 3 days credit. No return to this location at 2410 West Oak Ridge Road. Court cost $273 payable within 1 year.
Okay, sure, okay, thank you, thank you.
All right, Jane Michael, or your name, sir?
Gene Michael.
All right, sir. Sir, you have a charge of trespass after warning in a conveyance. Bond is $500. Do you want me to appoint a lawyer for you?
Whatever you think is gonna be best for me, Judge.
No, it's your decision, sir.
I don't think I need no judge.
He's saying to me, Your Honor, he does not want an attorney.
Does not.
He does not. I did
All right.
explain to him I'm a public defender, and I'm here to help him out.
All right, well, first, let's hear from the state as to an offer.
The state offers adjudication of guilt, 3 days, credit time served, court costs, no return to the scene.
And Your Honor, as a friend of the court, I just want to bring to the attention of the court that he has 0 felonies, 0 misdemeanors, 0 failures to appear. So just so the client, so the gentleman to my right understands, that he has 0 criminal histories in his history. So if he's pleading out today, he has to understand that he will have a criminal history as of today.
So you understand that, sir?
I'm just talking as a friend of the court.
Yes, no?
Yes.
All right. Then the plea would be accepted. There's factual basis stated here. There would be an adjudication, 3 days credit for time served. Court costs $273 payable within 1 year, and no return to 1715 Montview Street in Orange County.
If I don't accept it, so what is it?
I'm not sure. Say who's gonna represent yourself.
So you can ask the judge. You can ask the judge one question. You can ask him.
Judge, if I don't accept the plea that you give me, what's behind it?
Well, you could post bond, get out of jail, then you come back to court to answer to the charges, or you can, if you don't post bond, you could remain in jail and still have a trial later.
I'm gonna remain in jail and wait for a trial.
All right? That's fine. All right, the next file I have is that of Gwendolyn Rivera. Is that you, ma'am?
Yes.
Ma'am, you've got a case involving trespassing by failure to leave property upon order by the owner. You have a bond of $500. Do you want me to appoint a lawyer for you?
What are the further?
You have to speak up. You say yes.
Yes.
All right, public defender is appointed, Division A. Now, on this case, is there any offer from the state?
Yes, Your Honor. Adjudication of guilt, 3 days, credit time served, court cost, and no return to the scene of the trespass. Yeah.
Your Honor, my client accepts offer adjudication guilty, 3 days Orange County Jail, and no return.
All right. Then that penalty would be imposed, adjudication of guilt, and
3 days? when you
let's
have it
see,
out? Today?
3 days, get credit for time served, court cost $275 payable within a year, no return to this location at 233 East Main Street in Orange County.
I'm scared.
All right, next file is that of Arias Salazar.
Yes, sir.
All right, sir, you have a set of charges here. False information to a law enforcement officer during an investigation, bond $500, and petty theft, bond $250. Do you want me to appoint a lawyer for you, sir?
Would that be a public defender?
Yes, they're
Yes, sir.
lawyers.
Yes, sir.
All right. Office of the Public Defender is appointed. That's Division A. Now, on this case, is there any input from the, or offer from the state?
Yes, Your Honor. On this one, we would offer adjudication of guilt, 15 days, credit time served, court cost, and no return to the business.
1 minute, 1 moment, Your Honor, please. Your Honor, we appreciate the state's offer, but at this point in time, we're just not going to accept it.
All right. Next file is that of Brian Woods. Is that you, sir?
Yes, sir.
All right. Sir, you have a charge here of assault, bond $250, and public defender is appointed. Is there any offer from the state on this case?
Not at this time, Your Honor.
All right. That's Division CRA. Yes.
I have no way to get out. I have no money. Oh, okay, okay. Okay, thank you.
All right, the next file I have is that of Horace Black.
Yes, sir.
Sir, you got a Seminole County case. You're in a no bond status on that. So you'll be transported to Seminole County to answer to the charges there. And the bond on which you are released or stayed at this time. All right, the next file is that of Ashton Cacho. Is that you, sir?
Yes, sir.
All right. Sir, you have a Dade County case, and on that case, you're in a no bond status, so you'll be transported to Dade County to take care of the charges there. All right, Jessica Fournier?
Yes, sir.
Ma'am, you have a Polk County case. You're in a no bond status on that case, so you would be transported to Polk County to answer to the charges there. We can't take care of them here. All right, next file is that of Kirkens Guillaume. Is that you, sir?
Kirk Guillaume.
All right, sir. You have an out-of-county warrant, Seminole County. And you're in a no bond status, so you'd be transported to Seminole County to take care of those charges there.
All right, thank you.
Yes. All right, next file is that of William Medley.
Sir.
Sir, you have a set of charges, looks like, out of Hillsborough County. There's no bond on one, $500 bond on the other. So you would be transported to Hillsborough County to take care of the charges there.
Can I speak, sir? I know it said that, but I haven't have been there, and the girl been calling all day saying that she lied because she.
Well, you're just fine.
All right, next file is that of Sandra Vincennes. Is that you, ma'am?
Yes, no, it's not. My name is Sandra Robinson, but yes, Sandra was in, I'm under here.
All right, now you have a warrant out of Volusia County. A $10,000 bond was set in regard to that. So you can post the bond here or there.
Yes, sir.
So that's all I can tell you right now.
Thank you, Your Honor.
Yes, ma'am. All right, now, those are the only files I have. How long does the defense request to?
30 minutes, Your Honor.
All right.
Right, we need an hour.
An hour?
Yes, I have some PBLs, and I don't have anyone covering the afternoon session.
Oh, okay.
Thank you.
An hour it is.
So 11:30.
Letitia Fowler with the Office of Public Defender.
Adam Schill with the Office of Public Defender.
Elaine Fusco, State.
All right. Now, the first file I have here is that of James Sims.
Go back.
All right, your name, sir?
James Solomon Sims.
All right. Mr. Sims. Let's see. No PD request. All right, sir, you have a set of charges. Kidnapping, coercing commercial sexual activity, adult for human trafficking, no bond, deriving support from the proceeds of prostitution, bond $10,000, direct and transporting for purposes of prostitution, bond $100. Now, I do not have the request for appointed counsel here. So, sir, do you want to have a lawyer appointed to represent you at this point?
What he's asking is if you want an attorney to represent you right now.
Yes, yeah, I can. I'm gonna get one representing right now. So I was gonna hire one if I got a bond. I was gonna hire me an attorney and I got out.
All right. So, are you going to hire? Are you expecting to hire an attorney?
Yes, sir.
All right. Then, at this point, I will not appoint counsel. And this is Division 11, and the bonds are as stated. There is probable cause.
Your Honor, if I may, Your Honor, on Florida, as a friend of the court, due to the serious nature of the charge, and I'm not sure if the gentleman understands the serious nature of the charge, and no disrespect to him, I ask on his behalf that he resets it until he has time to speak to counsel and reset it tomorrow morning so he has time to seek counsel.
All right. Any input or objection from the state?
We can reset it to tomorrow to allow him time to obtain counsel.
All right. Reset for tomorrow. All right, next case is Jaslyn O'Neill. Is that you, ma'am?
Yes, sir.
All right, ma'am, you've got a charge here involving carjacking with a firearm. The warrant was issued. Now, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed. That's Division 14.
Your Honor, maybe we heard on bond at this point in time, Your Honor?
Yes.
At this point in time, I'm not sure if the state's going to take the approach of proof evident presumption great.
We are, Your Honor. In this case, Your Honor, the defendant and two others used a gun to threaten the victim and to obtain his vehicle, and the victim was later able to identify the defendant in a photo lineup, and she had a very specific tattoo that he was also able to identify. We would offer that there is proof evident presumption great and that he should be held without bond.
If I may, Your Honor?
Go ahead.
I believe we look at the four corners of the warrant and we take a step back. And first off, my client and the alleged victim knew each other, so her being in a photo lineup and him recognizing it would make sense in itself. If we read through the facts of the case, first off, my client didn't have the weapon. It was two other individuals that are not named at this. Second off, there's no independent witnesses, no independent evidence whatsoever that this alleged carjacking with a firearm took place. It's just the alleged victim at this point in time. There's no video, there's no nothing. My client didn't confess to it. My client wasn't arrested with a weapon or anything to that effect. So we're very far removed from that proof evident presumption great, very far removed. And so at this point in time, I understand it's a serious charge, but we also need to look at her record. And from what I had previously, and I've written it down, is 2 felonies, 3 misdemeanors, but the key is 0 failures to appear. That's what we're here for, the court, to ensure she shows up. It's not supposed to be punitive. As such, I asked for the court to set bond an amount of $25,000, Your Honor.
And state's response?
Our response, Your Honor, is that there is the identification of the subject is adequate at this point. If they want to revisit the issue after the information is filed, but I think for the initial appearance, the identification of a photo array by the victim is adequate, and she was known to him. And she was working together with 2 other people, but she knew that they had the gun. She was also saying to the defendant, get on the ground or they will shoot you, and she was working in concert with them, and she was one of the ones who left in the vehicle when the vehicle was taken.
If I may, just, Your Honor, for a follow-up point, and I'll be finished at that
ahead.
point. The state was making summations. The state was saying she worked with them. She was stating statements that are not part of the warrant. In initial appearance, we do not take information outside the 4 corners. The 4 corners does not say that. The 4 corners, as my client was there, she said, get down or they're going to shoot you. That doesn't say that she's working with them. That's someone saying, you have a gun on you, lay down. Watch out, you might get shot. Okay? From that state forward, the only thing at that point in time is the alleged victim is saying that she had the keys. That's it. So we are very far removed from proof evident presumption great, and I go back to it. Because of her criminal history, I asked for bond in a reasonable amount of $25,000, and it's $25,000 with acknowledgement that it is a serious nature charge. And thank you so much for your time, Your Honor.
And anything further from the state?
Nothing further, Your Honor.
All right. I want to look at a couple of things here. All right. In regard to the defense request at this time, I am going to set a bond amount. It'll be high. $100,000 with condition possess no weapons or firearms and have no contact where they are with anyone who is possessing a firearm in your presence. That's Division 14. All right, the next file I have is that of Rashawn Jones. Is that you, sir?
Yes, sir.
All right, sir, you have a set of charges here: trespassing in structure or conveyance, bond $1,500, resisting an officer interfering with a law enforcement officer without violence, bond $100, for a total of $1,600. Now, in regard to your paperwork here, I have no request for appointment of an attorney. Are you hiring your own attorney, sir?
I was going through some stuff yesterday, Judge, in regards to this. I don't understand what's going on, but Adam's here with me. He's going to help me, sir.
If I may interject, Your Honor, my client and I were working yesterday, and he's a lot better today. I'd like the Public Defender's Office to be appointed at this time. I asked the court if we can, so that we can assist him.
I agree.
All right. Well, at this time, I will appoint, at least temporarily, the Office of the Public Defender to appoint this defendant, and certainly he has to ultimately fill out the appropriate paperwork as far as qualification is concerned.
And if I may, Your Honor, on the amount of bond, if we can discuss bond in the matter.
All right?
The charges we look at is trespassing and then is resisting arrest without violence. And so I do want to make that right off the bat, that we're not talking about a violent act at this point in time. And I always go back towards myself as a failure to appear. Again, I reiterate, and I know I'm saying it again, Your Honor, but indulge me, if you may indulge me. His one failure to appear was 2014. And he does have a criminal history. So we look at 9 felonies and 2 misdemeanors. If we think about that, he's shown up to court. You know, he had 1 failure to appear in 2014. That's what we're looking for bond, for the purposes of helping yourself, to ensure that he shows up to court. So I ask at this point in time if we can do ROR on both charges, Your Honor. Thank you.
All right. And there's, well, okay.
The state would like to see at least $100, Your Honor.
All right, bond is $100 on each of the 2 counts.
I'll follow you out.
Thank you. Your name, sir?
Fred Bowen.
All right, sir, you have a set of charges. As far as counsel is concerned, your name, please.
Oh, Letitia Fowler.
All right. Now, sir, Ms. Bowen, you have a set of charges here. Possession of Xanax, bond $1,000. Possession of a firearm in commission of a felony, bond $5,000. Possession of drug paraphernalia, bond $500. Now, all right, I have the application for criminal indigent status. What's the situation? Are you with the public defender's office?
Yes, yes, Your Honor.
Okay, all right. Then the Office of the Public Defender is hereby appointed. And that is Division 14. All right, and the next file is that of Robert Carlin. He bonded
Yes, Your Honor.
$100,000? Okay. All right, your name, please.
Marie Elizabeth Di Giovanni, Your Honor.
All right, thank you. You've got an allegation here, ma'am, of possession of methamphetamine. Bond is $1,000. Now, based on the application for criminal indigent status, you do not qualify for appointment of the Office of the Public Defender lawyers. So you need to attempt to hire a private attorney for that. Now, see, your bond is $1,000, Division 12, and that's all I can tell you for purposes of this court appearance.
I can't speak, Your Honor. In the report I have, my boyfriend stated where it was his. It didn't belong to me. And the officer said if he said it was his like he did, she would let me go home, and here I am. It wasn't my belongings.
Well,
I've been in a lot of trouble in my life, and I would own up to anything I've done wrong. This is wrong.
all right, well, that's, this is without prejudice, so you can certainly, or your lawyer can, whichever, as to a motion for, an
Dismissal?
appropriate motion for release, whatever it might be.
Okay.
That's all I can tell you for purposes of this hearing.
Thank you, Judge.
All right, David Graham.
He refused, Your Honor.
All right, reset. All right, and the next file is that of Vladimir Guerrier.
Yes, sir.
All right,
Okay.
sir, you have a set of charges: burglary of an unoccupied structure, unarmed, bond $7,000, possession of burglary tools with intent to use the same, bond $300. Now, sir, on your application for criminal indigent status, you have provided information that indicates you do not qualify for appointed counsel. So at this point, I'm not appointing the Office of the Public Defender attorneys to represent you, and that's without prejudice to file another motion in that regard, should you want to. Now, this is...
This doesn't have a case number yet.
Hmm?
Our computer just set it up, it doesn't have a case number yet.
Oh, all right. No case number or division number at this moment in time. So that's all we can do for right now. All right, the next file I have is that of Dontavius Howard.
Yes, sir.
Is that you, sir? All right, sir. You are out on bond on a set of charges, fleeing and resisting without, and that bond is stayed at this time. Now, you have new charges here: possession of a controlled substance without a prescription, bond $1,000, possession of a controlled substance, again, without a prescription, bond $150. And possession of not more than 20 grams of marijuana, bond $100. Now, I have no application for criminal indigent status here. So what's your situation with regard to a lawyer?
I have Bruce Mount. That is my lawyer.
Who was that again?
Bruce Mount.
All right. All right, so you do have a lawyer then. All right, then that concludes this hearing for today's purposes.
Okay, thank you. Thank you.
Yes, sir. All right, Jamian Ishman?
Yes, sir.
All right, sir, you have a charge. Possession of methamphetamine. Bond is $1,000. And do you want me to appoint a lawyer for you?
No, sir. Okay, no.
You
No,
said
sir. No, sir.
you don't want a lawyer appointed at this moment.
I don't understand right now, sir.
All right, you have the right to have a lawyer. And in regard to this case, your application for criminal indigent status indicates you do have the right, you qualify for appointment of a lawyer from the Office of the Public Defender. You can also hire your own lawyer. I just need what it is you want to do.
Yes, sir, I would like one.
A public defender appointed?
Yes, sir.
All right, so ordered, and that's Division 20.
Your Honor, I see that he qualifies for PTR. Would court consider giving him PTR?
All right,
He
approved
has
and...
only one
and-
felony and 0 failure to appears.
All right, PTR is ordered. All right, and the next file is that of Thaddeus King.
Okay, thank you.
Your name, sir?
That is King.
All right, sir. A set of charges here. Driving while license suspended, and your bond on that case is $500. And then grand theft, third degree of a motor vehicle, your bond is $2,500. Now, on the lower charge, the Dwellis, you've got a $500 bond, Division A, and on the grand theft case, you have Division 10, and the Office of the Public Defender is appointed. So that's all I can tell you now, sir. All right, next file is that of Jacoy Massacott.
Yes, sir.
All right, sir, just a second. All right, sir, you've got a set of charges here. Possession of controlled substance without a prescription, bond $1,000. And counts 2, 3, 4 are the same. Bond is $150 on each of those. Then you have a charge of possession of not more than 20 grams of marijuana. The bond is $100 on that. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed. and that's Division 11. All right, let's see. Next case is that of Daniel Roman Gioga. Is that close?
Yes, Your Honor.
All right, sir. You have a couple of things here. Well, actually, one charge, but the bond has been corrected to $7,000 from $3,500. Now, sir, you don't have a request for appointment of a lawyer. Are you hiring your own lawyer?
Could I get a public defender, Your Honor?
If you qualify. Public defender have any history of?
I will get lawyer.
Say again?
I will get lawyer if I have to.
Well, at this time, what I'll do is temporarily appoint the office of the public defender to represent you, and that's to be made permanent if you qualify for the office of the public defender on a permanent basis.
Yes, Your Honor.
And that's Division 14.
And Your Honor, you stated that the bond was $7,000.
Yes, it was originally set at $3,500, and then that was corrected to $7,000.
And Your Honor, can we ask the court to reduce the bond to $3,500? It states that he has no history, no criminal history at all.
All right, and what's the state's position with respect to that request?
State can agree to the request.
All right, bond is once again set at $3,500 instead of $7,000, and that's Division 14. All right, the next file I have is that of Ciani Stella Diaz.
Correct, Your Honor.
All right, ma'am, you have a couple of things here I need to look at. You've got a charge on which you're out on bond.
Yes, sir.
Methamphetamine. That bond is stayed. And then you have a new case involving a charge of driving while license suspended or revoked as an habitual offender. And in regard to that, the bond is $3,500. Do you want me to appoint a lawyer to represent you?
Yes, Your Honor.
All right. On the new case here, the Willis while revoked.
I'm sorry?
The bond is $2,500. Now, do you, I've got here this case on which you're out on bond.
Yes.
It says here, your attorney's name is Gregory Williams.
I haven't been able to make contact with Gregory Williams as of yet. I do.
Well, let me ask you, did you hire him? Did
Yes.
you go see him, pay him money?
I haven't yet, but I have. I've only could speak to him by phone. I haven't contacted him in person yet.
All
My
right.
court date was just given to me not too long ago for December 5th for that case.
Well, now.
I'm trying to
does,
handle it.
Public defender have any knowledge as to whether Mr. Williams is in your office?
No, Your Honor.
Hmm. Well, at this time, the court would take no action in regard to that case on which you have bonded out. On the new case, I would appoint the office of the public defender in an abundance of caution, and that's the driving while license suspended or revoked as habitual offender, bond 2500, Division 14.
Thank you, Your Honor.
Yes, ma'am. All right, Taja Malik Brown,
He bonded, Your Honor.
all right. All right, the next file I have is that of Jarvis Harden. Is that you, sir?
He's mental health.
All right, reset. That brings us to the next file, which is retail petty theft, bond $250. And I have no request for appointment of the Office of the Public
What's
Defender.
the name on that defendant, Your Honor?
Say again?
The name, you didn't say the name.
Oh, all right. Tyree Daquan Quinn.
He's also mental health, Your Honor.
All right, reset then. All right, now the next file I have is that of Abderrashid Hassan. All right, sir. You've got an open container charge upon $250 is, let's see, public defenders appointed, offer from the state.
Yes, Your Honor, we will do adjudication of guilt, 3 days, credit time served, and court costs.
All right. Now, sir, you don't have to accept that offer. You can have a lawyer and a trial, for that matter. So, what is it you wish to do? And you'd have an opportunity to discuss this with the lawyer.
Your Honor, you'll accept the offer, enter a plea of no contest.
All right. There is a factual basis stated, so there would be an adjudication, 3 days with credit for, looks like 1 day, yes, time served, court cost $275 or $273.
You don't have a PD, right? Do you have a PD? 273, yes.
273 payable within a year. All right, the next file I have is that of Paul Clark.
He's mental health, Your Honor.
All right, now, yesterday, he was behavior problem. And do they, I think they can do, if they use a couple. Okay. All right, I'm going to provisionally appoint the Office of the Public Defender to represent this gentleman, Paul Clark. And all right, it has here on the form, Division TWY.
14,
All right, 14. All right, now the next case I have is that of Ray Lamar.
He refused, Your Honor.
All right, there was the same situation yesterday, so I'm going to appoint the Office of the Public Defender at this time under these facts. All right, the next files I have are that of Scott Sanders. Is that you, sir?
Yes, sir.
All right, sir. Now, you've got a failure to appear capious. You enter no bond status in regard to that. Then you've got another case here, petty theft with 2 prior convictions, bond $1,000, providing false identification to a law enforcement officer, bond $100. And I don't have any division, let's see. What is EAB?
16.
All right, Division 16 on that new case, and I have no division on the old failure to appear. Say 14, Division 14 on that case.
Your Honor, was the public defender office appointed?
Yes.
Yes. All right, now this next case, it looks like charges of aggravated assault with deadly weapon, burglary of a conveyance, attempted burglary of a conveyance, and looks like Judge Kirkland, let's see, he reduced the bonds, burglary of conveyance bond $1,000, attempted burglary of conveyance bond $150, and all right, now in regard to burglary of conveyance, there was to be a supplement filed as to count 1, burglary of a conveyance, according to the notes here.
Your Honor, the state is elected to let that go to the lesser charge of attempted burglary, and the issue could be revisited at the time the information is filed.
If I may, Your Honor?
Yes.
If I may. The state was given additional 24 hours, which I objected to at that time based upon initial appearance, 24 hours and probable cause, 48 hours. The judge and I, along with the state, discussed, because it was burglary conveyance, that at that point in time, we would just say attempted burglary conveyance for the purpose of the state be able to come back and say if it was burglary conveyance. The reason why I want to speak right now is that the attempted, they're asking for a lesser included charge of attempted burglary conveyance. My original argument that there was no probable cause at all. If they're saying attempted burglary conveyance at this point in time, that's 2 charges of attempted burglary conveyance. So i.e., there was 1 instance. So there is no probable cause with the additional charge of attempted burglary conveyance. So we should only have 1 charge of aggravated assault with a deadly weapon and the other charge of attempted burglary conveyance. There shouldn't be 2 charges of attempted burglary conveyance. And we take in consideration the judge did at that point in time reduce the amount to $150. So, my client would be saving $150, which, it's $150, Your Honor.
There were 2 cars, it's just that one couldn't be, I think, unlocked as of now, and one of them had the door ajar. And so there is probable cause for the 2. It's just a question of the one. We need to reduce to attempted for now.
And based on my argument yesterday, when I was with the judge yesterday in regards to the specifically burglary of conveyance, he looked towards the state, and if I'm saying anything wrong, please, the state can correct me, because I'm not here to say anything incorrectly, but for the state to bring any evidence forward that the actual door was open or something inside that vehicle. The way of my reading, and again, I could be wrong, at this point in time, we're saying 2 separate instances of attempted burglary of conveyance. At this point in time, there's only 1 of attempted burglary of conveyance if we look at the witnesses and everything else that's outlined in there.
There are 2 vehicles, Your Honor.
It's within the same.
It's just that one, the door was ajar, one not.
And my last comment on that, Your Honor, is yesterday we brought up my client had 0 felonies, 0 misdemeanors, 0 failures to appear, and that's why the judge reduced it. And I'll just finish it. One of the comments I may have said yesterday, or I didn't, ajar is not the same as open, and the statute says open, and that's why the court wanted more additional information, because ajar is, there's a reason why the police officer wrote ajar instead of open, because open equates with the statute of a burglary of conveyance. Thank you, Your Honor.
Your Honor, originally, the one that was ajar was listed as a burglary of a conveyance, and the attempted was of the one that wasn't open. So what we are saying right now is if we could just leave them both at attempted until we have more information that just isn't available right now, and they can address it again at the time the information is filed.
All right, the state's request would be granted, noting that count 1 is bond 1,000 and count 2 bond 150.
And then we'd stay the same one on the count 3, which would still stay the same at 150, which is the attempted burglary of conveyance, the one from yesterday.
Yes.
Thank you, Your Honor.
All right, now, I have run out of files, so it would appear that regrettably we'll have recess subject to call.
Thank you, Your Honor.